Introduce the panel. Uday Khare is a partner in the project finance team of Cyril, Amarchand and Mangaldas. Akshay Kamalnath is a senior lecturer at Australian National University School of Law. Christoph Paulus is a professor at Humboldt University and of counsel Wyden case in Berlin. And without further ado, over to you that present your paper on insolvency in real estate and a difficult balancing act.
Thank you, Ishana, and hello to yourself, to Christoph, and to Akshay, and to everyone listening. I'll try and keep it brief, seeing as we are running behind schedule, and timelines are important, both in the IBC as well as in our event today. So this is a sort of very specific paper and topic, as Ishana has already mentioned, and essentially I look at how the IBC has evolved to take care of the concerns of real estate allottees or home buyers, as they're more commonly known. The first 5 years of the IBC saw a lot of real estate insolvencies, mostly around North India, but also in different parts of the country, in Mumbai, in Bangalore. And I will sort of, in brief, trace the legislative evolution of how the IBC responded to the home buyers and their plight. And I think this is particularly important, not just from the perspective of the stakeholders involved, but also because it shines a light on how a new law like the IBC has adapted to the needs or adapted to a circumstance where a particular group of stakeholders was sort of left outside the process, and how it sort of responded to include them within the process, and I sort of then we'll go on to sort of talk about whether the way it was done was correct, whether it can be improved. So before I actually start on the home buyer question, there's two aspects of the IBC I'd just like to draw attention to because they are sort of fundamental to the home buyer question. One is, of course, a distinction between operational creditors and financial creditors, and more particularly the sort of unequal distribution of rights and privileges between them. So the financial creditors are the only creditors on the committee of creditors, which drives the resolution process. The operational creditors have essentially only a guarantee that they will get paid their minimum liquidation value. And also financial creditors are usually secured creditors as well. So even in liquidation, they are higher up in the waterfall. The other key aspect, which is also very fundamental to the IBC, is the concept of the time-bound resolution. So under the Act, if within 330 days a resolution plan cannot be approved, the company must mandatorily be liquidated. And this was, of course, brought in part to sort of counterbalance difficulties we had in the insolvency and winding up space previously, where companies languished for a long time in winding up, and previously in that under the SICA regime. And the Bankruptcy Law Reforms Committee report sort of made it clear that one of the main focus items for them when drafting this new law was to prevent delays, as essentially delays lead to value destruction and and therefore an inefficient process in terms of resolving insolvent companies. Now coming to home buyers specifically, initially when right after the IBC was enacted, through a couple of judgments of the Delhi NCLT, we arrived at a situation where home buyers were considered neither operational nor financial creditors. Apologies, the electricity is so the NCLT said that they are because they don't provide goods and services, they're not the recipients of goods and services, they are not operational creditors, and because they do not provide debt with the consideration of time value of money, they are not financial creditors. So consequently, they were left essentially remediless under the new regime. And of course, once a company is admitted into IBC, moratorium is in place. No person can sort of initiate new legal action. So effectively, they were completely disenfranchised from the entire process. Now, of course, this happens under a new law. This is not unusual for like a group of stakeholders to slip through the legislative cracks, as it were. What is interesting is the legislative response to it, and because also because there were so many real estate insolvencies at that time, it was a particularly sort of pressing issue for policymakers. So effectively, the IBC was amended to deem rather real estate allottees as financial creditors under the terms of the IBC. And this effectively, produced what one may call a logical inconsistency between the principles of the IBC as they existed and the inclusion of home buyers as financial creditors. And this is because essentially financial creditors have all the characteristics of an operational creditor. They don't put in money. They don't pay for their apartments with the intention of making a return on their investment. At least not your straightforward transaction. We do have specific transactions of that nature, but most home buyer sort of transactions are payment of money for delivery of an apartment or a flat, and it's only if, let's say, the apartment is not delivered that an obligation arises to return the money and often with penal interest. Now this was the justification used by the Insolvency Law Reforms Committee, which recommended their inclusion as financial creditors. Essentially that it's a tool for raising finance, and on failure of the project, the money is to be returned back. But this is the case with almost any contract of goods and services. Wherever you prepay to get a particular good, if you don't get the good, you're entitled to your money back and often with penal interest. So this, there was a logical sort of dissonance between the IBC and its principles and the inclusion of home buyers within their as financial creditors. This was of course challenged, and it was upheld by the Supreme Court in Pioneer Urban Infra. And their reasoning threw even further light on this dissonance. What the Supreme Court said is that for a borrowing, you don't need to have an obligation to return the money. Something equivalent will be sufficient to constitute a borrowing. Something equivalent in this case, of course, being the delivery of your flat or apartment. Now, again, that's exactly the case for every other operational creditor out there. So this was introduced, and then immediately, as soon as it was introduced, a new problem arose, which was voting. And now, of course, most home buyers are sort of ordinary citizens who don't necessarily have the time to go through information memorandums, resolution plans, negotiate with resolution applicants. So what we found was that for many of the items that required a positive vote of the Committee of Creditors, you just didn't have enough votes. More significantly, of course, the 66% that was needed to approve a resolution plan. So when you have a Committee of Creditors with a large sort of home buyer presence there, let's say, for instance, if it's 60% of the COC, if sufficient members of the class don't vote, you cannot approve anything. And so this problem arose. It was sought to be solved by the courts, but the IBC provisions don't really support either contention that was put up. And then finally, this was amended again to introduce the concept of deemed voting. So the way it works today is that if, let's say, going back to that same example, you have 60% of the COC is home buyers. If, let's say, only about 10% of them vote, then the majority decision of that 10% is ascribed to the entire 60%. So effectively, you have a small group of home buyers who will drive the entire decision-making, can drive the entire decision-making process, because most other home buyers simply don't have the time and energy to participate sort of, very vigorously in the plan. There are also other sort of many practical difficulties. So there is one authorized representative in the COC for all the home buyers. And of course, for a large company, this can mean thousands and thousands of people. and it's very difficult for that one person to coordinate with so many people. So effectively, what happens is the home buyers themselves sort of organize into different groups, usually through the resident welfare associations. So you have numerous groups with numerous sort of views and opinions. And that diversity of views and opinions can't really be represented in the COC because there's the lines of communication between the home buyers, the RWA representatives, and the one single member in the COC are just not clear enough for for there to be sort of meaningful dialogue. So that's kind of where we are today. That's how that's where we are in the real estate insolvency restructuring today. And I guess the question that we are here to sort of ask is whether this is correct, is this efficient, can this be done in a better way? And what I'll do is perhaps highlight some of the difficulties that have arisen as well as are foreseen for resolution in the current framework, and then I'll sort of turn it over to my fellow panelists to get their views on how how they see it in other jurisdictions and their perspectives from there. So first of all, if we take a typical COC of a real estate company, usually you will have home buyers and typically your other big class of creditors is your banks and financial institutions. Now and their interests are not necessarily aligned. Again, this comes out of the nature of stakeholder/creditor that they are. Banks and financial institutions, of course, the primary concern is the best recovery. Who can sort of give them back the most on their debt, and the quickest, who can give them back the quickest on their debt. Whereas for home buyers, it's typically, I mean, you can't generalize across the board, but typically the main interest is in getting the apartment back or getting the apartment that you were promised, and the quickest you can get the apartment that you were promised. So there is perhaps an inherent sort of interests are not really aligned between those two stakeholders. And a resolution applicant, potential resolution applicant, therefore has to sort of, if they have a finite, level of resources, has to choose where to allocate it. Do I pay the banks? Do I, put the money into construction and try and deliver these houses as quickly as I can? Now, this is, this is sort of not unrepresentative of misaligned interests in the COC generally, but I think here, considering that this amendment was made essentially to try and include home buyers and to protect their interests, one can question whether this is really a protective measure. It actually, because your voting power on the essentially your ability to decide the outcome of the restructuring or the insolvency depends upon your voting power in the COC. So if, let's say, home buyers are less than 34% of the COC, they'll have no power to sort of block a resolution or block a liquidation. On the other hand, if let's say home buyers are up to say 70%, then most likely the banks who may form the other 30% may not really get a good recovery. And I mean, let's not forget that the IBC was principally designed to bring in efficient resolution, and a big part of that is quick debt recovery. So it can be quite random. I mean, depending on how the COC is composed. The other problem that I've sort of already alluded to is that you don't it's not really possible to represent diverse views of a large group of stakeholders like home buyers within the COC, and so therefore what typically results is that for any particular sort of group of home buyers who feel they're not being represented properly at the COC, tend to express themselves through litigation. So therefore you typically see in real estate insolvencies a lot of litigation which are by various resident welfare associations, etc., who essentially don't have the space to make their views known within the COC. So that, of course, also tends to delay the process. Now, the main sort of criticism I have of the way things are today is that your threat of liquidation is unequal between banks and financial institutions on the one hand and home buyers on the other hand. Um, for, for banks and financial institutions, most of the time they're secured. So as secured lenders, they take higher up in the liquidation waterfall. So if there is a liquidation of the company, they would have a better recovery than home buyers, who in that situation would not get either their apartments or likely any money back. And therefore, uh, liquidation being such a sort of disastrous outcome for home buyers versus perhaps not as disastrous, although not ideal for banks, also sort of skews the negotiating power in within the COC. Now, I think what this has resulted in is that the courts have stepped in to effectively evolve a doctrine that liquidation in real estate companies with a large home buyer presence should be discouraged. And the precedent for this was set by the Supreme Court in JP Infratech, which has now gone through 3 rounds of CIRP, and it's currently sort of awaiting resolution. And this has happened in others as well. So, like in 3Cs, for example, where liquidation becomes a possibility, typically the courts sort of try and send it back to look at another resolution, or to see if it can be resolved without liquidation being the outcome. So effectively what we have and what this could potentially result in is a kind of limbo. We may end up creating zombie companies which are sort of forever in insolvency purgatory. We have, if liquidation can never happen, and if the market is unable to deliver a resolution, which is tough enough as it is because of difficulties in negotiation within the COC framework, it's we do run the risk of just companies continuing without either being resolved or being liquidated. And ultimately, this is probably the worst outcome for anybody, because ultimately the aim of the IBC, or the aim of any sort of insolvency law, is to have a degree of certainty as to what happens in insolvency, how assets will get resolved, and to do so in a sort of quick and efficient manner. Now, if we have insolvencies that drag on for years and years, then we run the risk that we will dissuade investors, whether it's home buyers, whether it's banks, whether it's equity investors within the real estate space. And of course, that is the outcome that would be the most disastrous. So, so these are the difficulties that sort of I see, and I'll stop here and throw it open to both the panelists on how they see this issue and their perspectives across different jurisdictions.
Thank you so much, Uday, for that very insightful presentation. I'll first invite Akshaya to give her thoughts, and then followed by Christoph.
Thanks, Sushana. I'd like to start by thanking you, JGILS, and all the collaborators for putting this together. It's been really, I think, a good initiative to be part of. So I'm a really big fan of comparative perspectives in insolvency law. So it's great if we can pull ideas that work from different jurisdictions. So I enjoyed reading your paper. It gave a really good practitioner's perspective, and I follow developments in India, but it's been hard to catch up on all the developments in this area because, as you've said, there's been so much. Every other day there was something new, so it's been really great to read your paper. I'm largely sympathetic with your arguments, so my comments will be more suggestions in terms of how to push further. So just to begin with, I think the paper which Ishana has made available in the chat starts very nicely with the theoretical foundations, which kind of goes to what Uday was talking about, the aims of insolvency. And it's an important question to consider before you think of any problem, right? So in the context of the type of arguments Uday was making about incentives, in the bargaining process, I would actually commend the article by Professor Anthony Casey, who talks about a Chapter 11 in the US being a kind of gap-filling exercise or a process that facilitates negotiation. And if we think in terms of that framework, we're really trying to think of the IBC corporate insolvency resolution process as providing an opportunity for stakeholders to kind of renegotiate certain terms in the contracts that don't work. And I think the paper also talks about how the home buyers specifically have these sort of unequal bargaining power in their contracts to begin with. So you kind of have an opportunity to deal with that situation here as well. So one thing I'd consider is incorporating mediation into the process, or even a kind of semi-mediation type situation where we take everyone's views, and rather than trying to negotiate for a zero sum, how much can each of us recover, think about how best we can collaborate and find a win-win solution, because we're kind of talking about a situation where we want to continue as a going concern, right? So we still need all the stakeholders. So thinking along those lines, and specifically because we have this problem of home buyers not really having a place in the IBC in terms of not being financial creditors or operational creditors, I actually thought of the Canadian cases, very distinctive cases where they considered social stakeholders. And this doesn't happen in every case, but specifically in cases where stakeholders, like I think there was a situation where there were an airline that was servicing a remote area, so the people of that remote area didn't have any other way to access the rest of the country. So very unique situations where you consider and allow social stakeholders to participate. And when I say participatory rights, it's not like how we've in India given them voting rights, but rather just to make representation in the court, put their views on the table so creditors are able to take that into consideration, and even the person proposing the plan, whoever's proposing the plan, can take that into consideration. So that I thought was a good idea to consider. There's a paper by Professor Virginia Torrey and Vern Dre called Social Stakeholders. They talk about the tobacco litigation in Canada. That's something to look at. And I think in terms of the coordination problem that you were mentioning with real estate home buyers, right? It's so real that whose views do you consider? And I've thought of the class actions where you try and certify, usually there's different law firms trying to say that for the same matter we want to be the class representative. So maybe in this context, you can have the court actually play that role and figure out who can be the appropriate representative, and that representative is able to come and make views of the committee heard, views of the home buyers heard. And you're right, there's a huge collective action problem, not enough incentive to participate, etc. So I think if we think this sort of thing kind of solves the problem of the real estate sector itself being affected, right? Because the bankruptcy system is important to have hold up the industry. To kind of think about whether the kind suggestions or directions I'm pushing you towards goes really against the spirit of IBC. I think the IBC has something about the court thinking about whether all stakeholders' interests are considered while approving the plan. So I'm just kind of saying, let's think of that a little earlier on in the day. With regard to your paper, I actually wanted to talk about two points. One point, you talk about judicial intervention kind of overcorrecting in this instance. It would be really great if you could kind of expand on that and talk about how this is actually becoming the norm under the IBC, which unfortunately was the case under the SICA, and we risk going back to that. And I think you do highlight that as a problem. So just expanding that as a wider problem than just the real estate sector. And the last point I have, is, I think you mentioned the case Flat Buyers Association and Umang, which talks about resolution of a single project. You call it a reverse CIRP. That sounds so interesting. I would really like to hear more. That's one area I'd really push you to explore further. With that, I think I'll leave it to the other panelists. Thanks so much.
Over to you, Christoph.
Excellent. Thank you very much. First of all, thank you very much, of course, for inviting me to this panel, which I really, really like. And I learn a lot, I have to say. And that brings me to your paper, Uday, that I read it with greatest interest. And I should make clear right from the outset that I'm now speaking as someone who comes from another planet and who has known so far little, if anything, about the Indian insolvency law, in particular the new IBC. So having said this, I want to concentrate my remarks on more fundamental issues about how do you design an insolvency proceeding or an insolvency law. And that is what makes me really puzzling about what is the intellectual background, what's the idea behind the split of financial creditors and operational creditors. Because it's an invitation, so to speak, to go into an insolvency proceeding, because there, as a financial creditor, you can gain some advantage over the other creditors. And this is a disincentive if you look at it from a market point of view. But to begin with, first of the topic as such, when I was confronted with it, when Ishana, who was friendly enough to invite me to speak here on this panel, when she gave me the topic of your paper, I was thinking about, well, this has a long tradition, of course, but that's a wrong approach to insolvency law, because when you talk about a particular set of creditors, then you address immediately compassion in the ears or in the eyes of the consumers, of the readers or listeners. Because we all identify ourselves with the home buyer, we immediately put ourselves in the shoes of a home buyer who has paid so much money, which was saved for such a long time and which was designed to build up your home. And then you're full of compassion. And then comes insolvency law, and all of a sudden you say, oh, we've got to do something. We have to help this guy. Okay, that is true. I mean, it's a perfectly right approach. But when you're talking about insolvency law, when you're thinking about how to best construe an insolvency law for an entire country of 1 point so many billion people, then you have to ignore to a certain degree this fate, at least on a general level, and you have to come from the other side. And you have to ask yourself, what is the main purpose of insolvency? And the main purpose of insolvency, you make some hints to it. I would go even a little bit further, and I would say the main purpose of insolvency law that I see is that it's the legal tool by which you transpose those assets in the economy which are less than optimal used, where their efficiency, their effectivity is less than optimal, that they are replaced to someone or to a place where their use is optimal. So where the best efficient usage is guaranteed. That is this kind of transmission. That is what I see as the main purpose of insolvency. Having said this, I would go further than you. You said that the purpose of insolvency law is to go quickly, to change things quickly. I would say additionally, it has also to be done fair. Brings me back to the approach of the individual, of the home buyer. He or she, of course, is suffering as any creditor in an insolvency proceeding. After all, we are talking about a common pool problem, which means that you as a creditor, anyone as a creditor, has to suffer a loss. you were promised 100%, you are about to receive less than 100%. That is painful, of course. Now, when you are in a group put together, the group of creditors, who are all bound by the loss because they have one thing in common, and that is their debtor. The debtor has not sufficient asset to pay you in full or to deliver and provide you with what has been promised in full. Then it seems to me to be a very fundamental, psychological almost matter, that a question of fairness consists in that we all share our losses. And that is the deep wisdom of the pari passu principle, the par conditio creditorum in an insolvency proceeding. If you have, like in the Indian IBC, if you have the distinction between the financial and operational creditors, it might even become attractive for some creditors because they gain there some advantage over other creditors, which they have not outside of insolvency, to go into an insolvency proceeding and to make use of it. And in order to overcome that, the best approach still is to have as few privileges, best would be no privileges at all, as possible. And when you set up principles, to be aware if they are really extremely fundamental. And in this context, that what generally worldwide is accepted to be generally throughout accepted privilege is those of the workers. Because that is so fundamental, because there we are talking about the foundations of billions, of millions and millions of families, and that makes a lot of sense. The next step would be maybe those who have a household, their home, and that is what you are talking about. However, when I was working at the IMF, we were talking about this kind of privilege. Shall we include in our paper a privilege for not home buyers? We didn't have that example in front of us, but of those who are renting, who are lessees of a house or an apartment. Should we protect them? Our response was, we should look more to those countries which are colder than India. And I don't want to be cynical, don't misunderstand me. I see the problem, but you have, when you are setting up an insolvency law, you have to find a regulation for, in your case in India, 1 point so many billion people. And not just for the 100,000 or million or 2 million people who happens to be home buyers and are suffering dramatically and tragically. So in this context, I therefore am surprised to see that you argue, which is perfectly fine, which is perfectly understandable, and probably also wise. You argue exactly as people are arguing in those countries in which you have already privileges. And I'm right now speaking here from Rome. And now I have to soften my voice because other people on the floor are Italians and they might hear it. Until recently, they had a chain of privileges of 43 privileges. So 43 categories of creditors were privileged as against those creditors who would receive in the end a little something, in most cases, nothing. What I want to say in this context is once you establish a privilege, and that is a worldwide, a global experience that we have, once you establish a privilege, you can bet that within a year, the next group of creditors will come and will say, oh, listen, when they have received a privilege, we are much more worthwhile to be privileged because we are much poorer, we are much more, deserve much more compassion, and what have you. So this is something where you have to draw a very, very fine line. I can't say anything for, particularly for India, with the exception of the privilege of workers. But beyond that, I would and I take the privilege as a complete foreigner to confine myself to this warning, refrain as much as possible from inserting a new privilege. Ishana, I'm done. Thank you.
Thank you so much, Christoph. Thank you, Akshaya. Indeed, very international and very pointed comments on the real estate and insolvency conundrum. I want to give Uday an opportunity to respond to both of your comments and views. We'll start there. Uday?
Sure. So thank you both for your insights. Maybe I'll take up the points raised by Christoph first, because I think possibly they are sort of more fundamental, the more fundamental questions. Exactly on the point of fairness and privilege, and it is, and you know, as Christoph already alluded to, there is already a mismatch between financial creditors and operational creditors, and the IBC came into being with a born privilege for one set of creditors over another set of creditors. The question, yeah, exactly. The questions of privilege and fairness are and where, I mean, home buyers really are just an example here, to be perfectly honest. But we're talking about something much broader than that. We are talking about, the ability, to what extent should privilege be granted. The distinction or the privilege granted to financial creditors to begin with, this was introduced by the IBC under our sort of previous, winding up regime. You don't have this distinction, and I don't think you have this distinction in most other countries in the world either. The only sort of distinctions that we used to have were between secured and unsecured creditors. So now suddenly we have created these two sort of unequal sets of creditors. The justification for it, which I'm not sort of advocating, the justification for it was that financial creditors would be in a better position because this is their business to evaluate the question of restructuring of a company as a whole. It's a distinction very much based in what is the perceived reality in India. I have my own sort of reservations around it. I have my reservations around the justification for it. I don't really think it stands up. I mean, we've had cases where you've had financial creditors who've been sort of something like 10 million, and you've got one operation creditor sitting with a 50 million claim, who has no sort of say in the resolution. So I don't think it's an ideal situation to begin with. And then on top of that, when you sort of look to introduce, what I find concerning, and I'm echoing Christoph here, is if you're seeking to grant privilege to a certain group of stakeholders or creditors, and you're doing so by putting them into Class A and saying they're as opposed to Class B. So you already have an existing inequality, and if the solution to it is going to be, I will put you in Class A, I will put you in that group rather than that group, then I think even more so, even more than just being granted privilege, I think that's what everyone is going to aspire to. So the next group of creditors, or the next group of stakeholders who are looking at seeking a greater voice and a role than they have today, will ask for exactly that. The justification for including home buyers as financial creditors, given your entire FC OC distinction, is anyway thin. So the next time this may well be how it transpires. What I actually so I agree. This is not something that is inherently fair to begin with, and I think the means of trying to protect a particular class of stakeholders is by essentially just making them a privileged class. I think the question is still sort of open as to, is there a better way to protect them? employees and workmen, for example, another vulnerable class, are, their protections are sort of pretty consistent across many insolvency jurisdictions in that, they are entitled to preferential payments from a liquidation in many cases, or from a resolution plan. I don't think you can replicate that for home buyers simply because the amounts are too vast for home buyers. But potentially, there may be other means to do it. And here, maybe, I'll sort of talk a little bit about the reverse CIRP, which Akshay had talked about. And it's an interesting judgment. It's a bit of a it's a buccaneering judgment in that it completely sort of ignores the actual regulations and the actual procedure, because the entire IBC is around the insolvency of a company and not a particular project of a company. So, what's your question going to be? Yes, you have a resolution professional who look at the company, but will he then take over the whole company? Will he take over the project? How will he interact with the existing sort of management who under the IBC is supposed to be out as soon as the resolution professional is in place? But I agree, it's an interesting idea which could be legislatively provided for. The main merit I see in the idea is that you then maybe localize the impact of a particular insolvency. So if there's one particular project in trouble as opposed to the others, then you can deal with it separately without needing to drag the company's creditors, all the other sort of home buyers into that particular restructuring. But I fear that it may not be necessarily useful in all situations, because to have a situation where you have one project which is in trouble and you allow sort of the home buyers to get together and build a project and invite sort of bids by themselves, it's not a situation you'll face too often. So because the sort of big insolvencies we've had, the company is insolvent, so the impact is felt across projects. Nevertheless, I think it's a good idea. I think it's a good idea for to try and go the other way from a group insolvency to something that is more specific to a particular asset of the company. I'll just touch upon also the judicial overreaction that Akshay mentioned. Yes, you're absolutely right. I mean, this the whole question or the whole resistance to liquidation is not unique to the real estate space. And there is a judicial reluctance, which I think is a reaction to the sort of hard-nosed, highly proceduralist model that the IBC has prescribed. 330 days, no resolution plan, you're done, liquidate, right? So we already see courts sort of granting extensions due to various events. Of course, during the pandemic was one of the main sort of reasons for extension. But if you can convince the court that just give us another 30 days, 40 days, we have XYZ offers, we can sort of resolution is possible here. Courts are generally are more inclined to allow that. And I think that I think the fundamental reason why courts have sort of reacted this way, well, two fundamental reasons. One is, of course, the role the courts have always played. So the IBC also sort of seeks to change the role of the judiciary within an insolvency, and try to limit their role as much as possible to just check A, B, C, D. If the resolution plan satisfies these, pass it. If not, liquidate. Time is up. That's it, right? And that's I think that's something that that's very different to how the courts in India have traditionally played a role in insolvency resolution. So I think there is a cultural history there which is difficult to sort of just push against through one legislation. But the other sort of key factor here, I think, is also the IBC is predicated on a market-driven resolution. So the effective principle, if I can just express it in a couple of sentences, is that you create the conditions for the market to provide you a solution on a going concern basis, and if that fails, then just liquidate, sell the assets, and that is the best economically efficient way of dealing with an insolvency. And I think what has happened is we are seeing a lot more liquidations than resolutions. So, basically, as per the Economic Survey of India, between April 2019 to December 2019, there were sort of 381 liquidations as opposed to 89 resolutions. So that's a very high number of liquidations. Now, of course, we can't forget the fact that we are also in a pandemic, and that definitely impacts the ability of the market to provide solutions and provide resources to achieve effective restructuring. But even before that, I think this was the trend that was going. So if we were to follow the economic logic of the IBC now, we should have a lot of liquidations. But given just how real this problem has now become, as to that suddenly, yes, sure, theoretically it's fine, but yes, now in fact almost every third, or well, 2 out of 3 are going into liquidation, and I think that's another factor that has caused courts to sort of react the way they have, and particularly in situations involving, say, home buyers, where you can clearly see a large sort of group is going to get severely disadvantaged by liquidation. I think that is that has sort of exacerbated it. I mean, you see it in other situations as well, where, let's say, we're talking about employees or workmen who will lose their jobs if there's a liquidation. But the home buyer case really drives home that sort of role that the judiciary sort of sees itself playing. So yeah, I mean, there is definitely an overreaction. I would say it's more than just an overreaction. It is a possibly a struggle to accept the economic logic of the IBC and what it actually entails in the real world. And I mean, I have some sympathy for the judges there, because you are it's one thing to have a sort of law made in conference room, in meetings, and it's another where you are faced with the direct results of it. So I mean, I have some sympathy there. I mean, I don't have strong views on whether they how, to what extent they should be allowed to. I mean, I think there is a risk of judicial overuse of discretion, and that should be curbed. But at the same time, I mean, personally, I think I'm open to sort of solutions for particularly complex situations like this, and the concept of social stakeholders that Akshay mentioned is, I think, another. It's a good idea, but I fear we are too late for it, because as Christoph said, once a privilege has been given, it's not going to be taken away. So once you've granted the voting rights, I think it's going to be near impossible from a policy perspective to take that back. Maybe you can use it for future groups of similar nature, but I think it's going to be very difficult to walk back from the position we are now.
Thanks for that response, Uday. Christoph, Akshay, if you have a thought here, or I can just ask the moderator question and combine it with one question from the audience, and we can then get into closing remarks. Is that all right?
Perfect.
All right, great. So the one thing that I'm kind of smiling at is the fact that we're all trying to navigate the idea of how do you take away rights vis-a-vis a particular class of creditors, which should not have been given rights in the first place, as an underlying theme as well, in terms of judicial activism and overreach, which wasn't supposed to be the case in the insolvency law metric to begin with, which is why there were limits on adjudication that were placed as well. Now, I want to combine two questions here because there is an underlying theme, even from the previous session, about specialized laws and how the IBC is interacting with it. Particularly for the real estate sector, we did have a RERA that had been introduced, which is the Real Estate Regulatory Act, to provide resolution and personally, I do believe that a case like JP, which sort of set the precedent of home buyers, should not have gone through the IBC process to begin with. The home buyers cases should have been treated under the real estate legislation, primarily because when they went into the IBC process, we didn't know how to treat them, perhaps. Instead of following the timeline and following, if you don't resolve, let's liquidate, we ended up doing a clock reset. We ended up doing a situation of exceeding perhaps what was envisaged under the law, and also paving way for consumer bankruptcy, which essentially is a huge concern, I think, for the place of insolvency law in India, which is now back in action. So I just want to kind of go around, starting with Akshaya, then Christoph, and then Uday to close on what are your perspectives, what are your thoughts on having this kind of conflict, and having now the concept of consumer bankruptcy being just out there in the Indian insolvency regime today.
Akshaya, do you want to start?
Yeah, thanks, Ishana. Yeah, I actually don't have a problem with them using the IBC. Wouldn't, I mean, I might, if I think that this is some kind of tactic used by operational creditors, right? Going to the IBC if their debts are not paid and just starting insolvency proceedings. And I don't think there's anything wrong with someone who does not have a category there trying to see, oh, let's try my luck. Let's see if I get some judges to kind of support my cause. So sure, that it's there and they tried it. And I don't think just because you have a specialized law, insolvency law should not be out of reach, right? If these companies are actually not viable or having real cash flow issues, then absolutely insolvency is the place for it. So I have no problem with that. It's just that we happen to come across this problem where we don't know how to classify the home buyers, and it had to get resolved. So just I'll add here that unlike Uday, I feel quite strongly about this sort of judicial overreach, because this is the kind of thing that kept happening under SICA, and we should have known better and not gone down that path. And more of a place for the market to have resolved itself. They should have allowed some of that. I think the next question, what was your next question? Consumer bankruptcy, right? Again, I was thinking, yeah, to one extent, I think if I think of it as two different points, right? If the home buyer as a consumer becomes bankrupt because of this money owed, losing this amount of money, and then we're trying to think, oh, do we have a good effective personal bankruptcy regime in place? On the other hand, what is the role of these if there's a huge class of a certain type of stakeholders that are affected? We should absolutely still have their say, especially if you want to continue this process as this company as a going concern. So without repeating myself, I think I'd say there's a place to listen to their views. There's a place to collaborate and try and find a solution, because these are all stakeholders the company still has to work with if it remains as a going concern. So yeah, I think there should be this is a good kind of discussion we're having to think about, not just home buyers, but what happens next when you have, so in an airline, what happens to all those who had booked tickets? Or I think in Australia, there was a situation where some chain of retail stores went bankrupt, and what happens to all the gift card holders? So these sort of things come up in different sectors, and we have to have a way to include their views and try and resolve that. So I'll stop there. Thanks.
Shall I?
Yes, Christoph.
Okay. I mean, your first question, it's extremely fascinating. Makes me smile also to a certain degree, because it's about the ranking or the hierarchy of national laws. And where in this hierarchy is the insolvency law? It used to be at the end very down on the pyramid. So it was seen as something, the cleaning up procedure, and you should, I mean, that was at least the predominant sentiment in Germany and in huge parts of Europe, that insolvency, you don't deal with insolvency law, and if you do, you are some way, somehow crazy. You are the cleaner up, the cleaning person. This has shifted. This has shifted in the last 25 years, and the initial starting point for that has been the East Asia crisis in the end of the 90s. There they discovered the centrality for the functioning and the financial stability of any nation and economy. And if you now look up, and that's an immediate consequence of the G7 meeting, which took place, I think, in 1998. The consequence was that the Financial Stability Board was founded. And if you look at the website of the Financial Stability Board, you find now 12 key factors for the financial stability of any nation. And one of the key factors is insolvency law. So they found out that you need to have, in order to have your economy clean, so to speak, and viable, you need to have an effective insolvency law. And for that reason, coming from this approach, I would say it's not a question of a specialized law somewhere dealing with the real estate. It is the question of, it's the area of insolvency law. That is exactly where insolvency law is developing its power, and it has to be given the chance to develop its power. So therefore, I would, like Ashana, I would clearly vote also and plead for the preponderance of insolvency law. Speaking of consumer law, I mean, it's not a surprise, coming back again to my multinational institutions. It's not a surprise that something like 3 or 4 years ago, the World Bank came out with a compendium on consumer insolvency law. They have discovered, and they found out, I mean, yesterday you had Mahesh. Mahesh was probably also talking about, or he was addressing also the consumer insolvency law. It was his idea that you come up with you need to have something for consumers, because it's by now not any longer an individual problem, it's a macroeconomic problem. If you don't deal, if you don't have a remedy for them, they would be burdened by the load of debts, and they would be outcast from the society. I mean, that is what is behind this initiative of the World Bank. You want to prevent the societies to split into two parts, the haves and the have-nots. You still have them, but you accelerate this division by not giving the consumers a chance to get out of their guilt tower, so to speak, and out of their prison. And for that reason, I'm also strongly pleading for start at the university in order to convince the decision makers to enact a consumer insolvency.
Thank you for the insight, Christoph. Uday, over to you to respond and close.
Yeah, so I think I'll let me take the question of RERA first and specialized legislations, and going very much the question of what you said, should JP have been one of the ones referred under the IBC? And that's a good question. I mean, JP was, when the IBC was enacted, the RBI and the government in general were in debt cleanup mode, and that's why they were excited about the IBC. It was seen to be a means of recovery, a means of sort of settling debts that had been going on for far too long. And of course, initially we had, the dirty dozen, of which JP Infratech was one. The first, the big 12 to sort of go into insolvency, where the RBI actually directed the lead banks to take it there. So, I mean, not only was it a situation where could they have prevented it, it's a situation where they actively sort of, directed that it go into insolvency. I think no one anticipated the home buyer impact or how the new law was going to impact them. So, I mean, you had at that point what was a brand new law, and the RBI and the government were keen to sort of test it. So, in a way, the situation we have today is a consequence of that testing. So, definitely, yes, they could have sort of thought about it a little bit more. An interesting parallel there is, companies that provide financial services. You could not initiate IBC under them until the financial services rules were enacted, and today you can only do so with the RBI's go-ahead, and the RBI will also appoint the administrator. So you could have thought of something similar for real estate companies. I don't think RERA though is the substitute, because RERA has a very different sort of objective, and it's RERA is there to sort of bring about a more robust governance oversight mechanism for real estate companies. So really, RERA is designed for future projects, and potentially RERA will work. I mean, we will see. But it came in at about the same time as the IBC. I don't think RERA could have at that point of time solved the large insolvencies that were going on in the existing real estate companies. So I don't see RERA and the IBC as conflicting in any way. I mean, they are legislations designed for different purposes, and hopefully, if RERA succeeds, you will have less insolvency under the IBC. But of course, once you hit the point of insolvency, there your insolvency law has to take over. As the hierarchy of laws question is an interesting one, and I think that this is also one of the sort of debates that go around the role and purpose of insolvency law worldwide, because you have a strong school of thought that says you should not create special privileges in insolvency, that they should be reflective of the bargain that the creditors have struck with the corporate debtor. I mean, there are equally compelling counter arguments to that as well. But I think the primacy of an insolvency law cannot be avoided, particularly given we are currently in a situation of financial crisis, and I think COVID is going to exacerbate this even more. So I think for the time being, I think what needs to happen is to make the insolvency process as efficient and smooth as possible, because you cannot avoid it at the end of the day. Coming to your second question on consumer protection, and you're absolutely right. I mean, that's what home buyers are. They are consumers. They're a specific class of consumers, but as such, they are no different from every other consumer. And I think this is why I feel some sympathy to the need to take urgent action to protect home buyers. Although, of course, I can see absolutely no reason why you should protect a particular class of consumers versus other consumers. I mean, I think we should have something more holistic. But as any consumer, you are in an unequal bargaining position with the credit, with the corporate debtor. Very similar to, as Akshay pointed out, airlines. And in fact, interestingly, after the pandemic, when a lot of because of the lockdowns, when flights cancelled, flights had to be cancelled, monies had been collected. The question of what to do with those refunds became quite a thorny issue as well, and that went up all the way to the Supreme Court, who has, ultimately, in a way, the Supreme Court becomes in many cases the arbiter of the negotiated settlement, and that's kind of what happened on the airlines front as well. So refunds were ordered for up to certain dates. Then obviously, if they were booked after lockdown, they were not ordered. So that's precisely the scenario that laid out. And we did, of course, have the insolvency of Jet Airways in this time as well, which was also very significant, in that context. So another example I can think of are potential patients to a hospital. You have in India, you have healthcare coverage, which is in many places there's only one hospital, which will serve a large area. Now, of course, most of these are government hospitals, so you will probably not face the insolvency problem. But in many cases, they are private hospitals, and if you are ending up liquidating that center, then you are ending up in a situation where essentially it's consumers who are suffering. So I think there is some scope, potentially at government discretion to step in and to sort of take actions to protect a particular class of consumers without necessarily changing the rules of insolvency law or adding new privileges, etc. I mean, you do have government rescue, which is something else which, the IBC, of course, sought to provide purely capitalistic market-driven solution to all matters insolvency. But like in the real estate space, actually, you had NBCC, which came, the National Building Construction Corporation of India, which is the government owned, which actually came in JP, in Amrapali. So it is possibly a recognition that the formal systems or mechanisms of insolvency resolution have not worked. So possibly there is scope for government rescue. Now, I think the real debate is whether we should whether these kind of protections should be something that are concretized into law, into the formal legal system, as they have done with home buyers, or whether this is something that possibly should be left to to be dealt with as they arise in a manner that is not going to cause your insolvency resolution process itself to sort of come to a halt or to get frustrated.
Wow, that's a lot of food for thought to close this panel discussion. I want to thank Christoph. Thank you very much, Akshay. I know it's very late in your time zone, for providing insights on insolvency in real estate. And of course, Uday, the combination of narrative and theory is quite excellent and allows us to segue into another panel where that is narrative and descriptive, that is combined, which is our last panel for today. I'd like to invite Satish Kumar Gupta, Debanshu Mukherjee, and Robert Hanel to discuss the last paper of the launch series, which is titled "Treatment of Disputed Claims in Corporate Insolvency: The Evolving Jurisdiction." Thank you all very, very much for joining us and staying with us for the entire duration of the session. You can find the paper written by Satish and fortunately me here in the tab, and I'm going to allow Satish to start the presentation and give a brief overview of the paper, and then seek responses from Robert, followed by Debanshu. I know we've Googled them already, but 30 seconds on who these people are. Satish Kumar Gupta, of course, is a renowned insolvency professional. He acted as a resolution professional for SR Steel, one of the biggest insolvencies that India has seen, and one of the biggest insolvency resolutions as well. His name has gone down in history in terms of insolvency-related literature, because versus Satish Kumar Gupta is a normal for classroom teaching. We move to Dr. Robert Hanel, who has, again, quite amazingly academic at heart, but a hardcore practitioner of insolvency law. has contributed very heavily to international insolvency, particularly European and German insolvency, and is presently a partner at Anchor. Then we have Debanshu Mukherjee, who co-founded Vidhi Center for Legal Policy and was instrumental as a part of the drafting committee of the insolvency law as we see it today. So briefly about them, and over to you, Satish. I'll